How you going, people? This is a pretty interesting little case here. An attorney gets arrested. There's going to be all kind of little legal issues and innuendos or if and buts and coconuts. But I'll try to give you my opinion on my experience with warrants and seizures and the courts. So this was on Audit the Auditor. I already subscribed and I hit liked, like a good little YouTuber that supports people exposing government. Anyway, let's take a look at this, and I'll pause it and talk it through.
Victor Revel and Megan Garcia were leaving the courthouse with their client, Lloyd Edwards, after appearing in court in reference to a protection from abuse order initiated by Mr. Edwards' wife, Jasmine. Before leaving the courthouse, Mr. Edwards gave 2 of his 3 cell phones to Mr. Revel. As Ms. Garcia,
Okay, so he gave 2 of his 3 cell phones to his attorney. All right?
Mr. Revel and Mr. Edwards exited the courthouse, they were confronted by Deputy Ashworth and Deputy Ratliff of the Blount County Sheriff's Office in Blount County, Alabama, who were attempting to serve a search warrant of Mr. Edwards and his vehicle.
I'm from the Sheriff's Office.
I can't believe this is a deputy. I mean, look at this way this woman runs up here freaking wearing a tent. And she ends up arresting this guy. So, here's some of the problems that we're going to see here. The cell phones are in this case. This is the client. This is his attorney. In legal things, the attorney's investigator or assistant or paralegal has the same confidential powers, so to speak, as the attorney. So if I'm working for an attorney as an investigator, not the DA, that's different. If I'm working as an investigator or an assistant to an attorney, anything that I hear or see is confidential, and you can't breach that unless you're Donald Trump and they want to get your attorney to turn on you. Other than that, most attorneys never are allowed to breach attorney-client privilege or they're disbarred. So this woman can't divulge or give any information that she hears. People misunderstand sometimes that attorney-client privilege is negated or doesn't apply if there's a third party there. And in criminal cases, they get around attorney-client privilege because if there's a third party in the room, you lose the privilege. It's not considered privileged information, which is why a lot of attorneys only want to talk to you by themselves because they don't want to lose that. Now, if his investigator's in the room or his paralegal, they kind of fall under the same umbrella as the attorney, so they're okay. But if you talk to your attorney in front of your buddy, I think even your wife, because unless he's representing both of you, that would be a legal issue I'm not sure about. But if any other third party is in the room, you lose your attorney-client privilege protection. But you don't lose it if the person works for the attorney and is considered, anything that this person develops is considered part of the attorney's work product. Therefore, it falls under attorney-client privilege.
Do you have any other weapons on your person at this time that I need to know about or say?
No, sir.
No,
I
now?
do in the car.
Okay. What do you have in the automobile?
A small pistol.
Okay. Your vehicle is also part of this search. Okay. So I'm gonna have
Okay, so he's searching for when the guy volunteered. He's got a weapon in the car. Should never volunteer anything to the police. The attorney probably wanted to say, keep your mouth shut and don't answer questions. But the guy volunteered. He's got a gun in the car. Well, they're serving a warrant from a protected order. If they have a protection order, that means he's not allowed to have a weapon. So he kind of screwed up because he ran his mouth when he didn't need to by talking to the cops. Nothing good ever comes from cooperating or talking to government. It can only be used against you.
ask you, do you have the keys to your automobile?
Yes, sir.
I need the keys.
This damn woman right here works for the sheriff's office. She's a freaking complete mess. Digging around, no officer safety. I don't know where the hell she's got her gun. Don't know if she can get to it if she needs it. Looks like a slob. Wow.
Your automobile right now. Okay. Let me pat you down, make sure you don't have any other weapon. Just for your safety and ours.
For your safety and ours. It ain't for your safety, dude. I guarantee you. When government starts searching you, it's not for your protection or your safety.
Okay. Just hang tight and we'll get all this resolved.
As mentioned earlier in the video, Mr. Edwards was appearing in court about a protection order issued by his wife. Mrs. Edwards alleged that Mr. Edwards had abused her and their daughter, and testified that Mr. Edwards' cell phones contained proof of her claims. Mrs. Edwards' testimony led the prosecution to pursue a search warrant for Mr. Edwards' person and vehicle.
Okay, so that's what we call probable cause. The wife, who isn't what I would call an unbiased party, said that her husband abused her daughter and her, and that there's evidence on a cell phone. In order to get a search warrant, a peace officer has to believe, one, that a crime was committed, and that, two, he believes there's evidence of that crime where he wants to search. And remember, it's a very low, people think, oh man, you really got to have a lot of information to get a search warrant. No, you don't. Most cops that tell you that have never written one. It's a very low standard. The standard is, for me to get a search warrant, is a fair probability that I will find evidence. That's it. So when an abused victim, especially when you bring children in it, a child is abused, and the mother says, oh, there's evidence on a cell phone, most DAs and judges are going to say, that's probable cause for me, let's get a warrant. We got nothing to lose and only things to gain. Why not get a warrant? And so they went and got a warrant.
Specifically targeting his 3 cell phones. I called the Revel law firm, and Mr. Revel stated that,
okay, since they're specifically targeting the 3 cell phones, the wife had to give a better probable cause statement, probably that he took pictures or video, or I took one of his cell phones and I took pictures that he don't know about it of my child's abuse, or my damage, or my black eye. So now the wife is corroborating that she knows firsthand that there is evidence on these cell phones. So the DA, being diligent, says, I need to get these cell phones. So they issue a warrant. Now, I haven't seen the warrant. If they put in a warrant that I want to seize the cell phone, that's one thing. But if they said I want to search him and look for the cell phones, then they're only looking for the cell phones. A good warrant would have been written, I believe there's digital evidence on the cell phone, either in pictures or in video, and that this evidence is concealed on the cell phone. But when I search, I also want to look for other evidence that this digital evidence could have been downloaded to, such as discs, CD players, cloud drives, hard drives in a computer, thumb drives. They want to be able to search everything. I don't know what the warrant said. I don't know who wrote the warrant, but it seems like they're focusing on these phones.
that there was no evidence of abuse on the phones, and that the phones actually contained evidence that supported Mr. Edwards' innocence. Mr. Revel claims that Mrs. Edwards had exchanged explicit messages with Mr. Edwards, which indicated that her interactions with him were consensual, and that he intended to submit the phones as evidence for the defense.
Okay, so this guy, whoever this audit is saying that, and he's just saying what he was told. I don't know if he has firsthand knowledge or not. Maybe he does. But they're trying to point out that she's trying to get these phones because there's things. Once these phones are taken as evidence and they make it, even if it goes against him, the prosecution's by law is supposed to discover. Now, we all know that DAs lie all the time, and they're probably the biggest crooks in the criminal justice system because they get immunity. So maybe they could destroy the text to help their case. I don't want to believe that these cops and DA are trying to get these phones to destroy evidence to make their case better. But they've got a person that said there's evidence on there. They've got a right to ask for a warrant. They asked for a warrant, and the judge signed a warrant. So the warrant is good. The question here is the warrant for the attorney, or is it for the cell phones and which should they have done? I think they messed up, but we'll see.
Mr. Edwards later stated that Mr. Revel told him that, quote, there may come a day when the prosecution wants your phone. And one of the attorneys asked him for the 2 phones just before exiting the courtroom. The phones were then placed into Mrs. Garcia's briefcase prior to exiting the building.
Okay, so they ask him for the phones. Why do you think they asked for the phone? Well, Rick, they're crooked and they're trying to hide it because the poor woman's the victim and everybody hates whatever. They asked for the cell phones because they want to look at it and see if there's anything damaging. Remember, in the O.J. trial, for those who are old enough to remember, when O.J. Simpson was arrested for killing his wife with the bloody glove, he gave the knife that he used to his attorney, and his attorney could never get that knife in because the attorney cannot be compelled to discover evidence that hurts his client. That's part of the attorney-client privilege. So the knife, because it was given to the attorney, the prosecution could never get it and was never got in court. They got the bloody glove in, but when it didn't fit, they acquitted because of color, not because he was innocent. And there's a lot of people running around, he was innocent, the jury let him go. Just because the jury lets go don't mean you're innocent. Just means they voted not guilty. They either jury nullified and said, I don't care what the evidence is, we're voting not guilty, or the prosecution did convince them to vote guilty.
The warrants that you all have are for his person
That's correct.
and for his vehicle.
That's correct.
Okay, so he read the warrant, and he said, the warrant that you have is for his person and his vehicle. What does that mean? It means that when the warrant was issued, they asked to search his person and the vehicle. Now, they may have put in a warrant, we want to search his persons and vehicle for the cell phones, or for one of his 3 cell phones, or for all 3 of his cell phones. But it doesn't matter. When you get a warrant, you have to write with specificity where you're going to search and what items you're searching for. They put in a warrant, they want to search him and his car. That does not give them the right to search his attorney or that. But Rick, if she has a phone and they're looking at her phone, why didn't that do it? And didn't that exit search? No, it isn't. They do not have the right to take these phones from these people. So what do? They end up arresting them. Now, incident to arrest, they can search their bag and seize the evidence.
So he is given the phone that's on his person.
Okay, I have video of him handing the phone to you, you handing the phone to her. It's in the satchel right now.
Yeah, you all do have that, but that is not on. When you all
No, I'm
came
out
on
here at
him
the courthouse
to serve
with
this
Brian
search
on
warrant,
the search
that was
warrant.
not on his person. So you all are not entitled to that.
Okay.
The lawyer is correct. They are not entitled to the 2 phones that are not on his persons. It is in their possession. The warrant only dictates him. Now, if they would have put in a warrant, we want to search this party, Joe Johnson, whatever, and his car, and anyone in the presence of him that he hands the phones to, then they could have got the phone. But a judge probably wouldn't have signed that, because what if this guy's standing in Walmart and now you get a warrant to search anybody around him? Now you can search everybody in Walmart because you got a warrant for him. Then you would have cops getting warrants for somebody to search anybody, and they wait till they're with the person who they really want to search, but they can't get a warrant, and then they can search them. So no judge is going to give a warrant and sign a warrant with that kind of stipulation. Their warrant is for him and his car. They have no right to these guys of the phone. Now, hang on, I'll let it finish and I'll get to that.
Well, I can. We'll go the other route to get that other phone.
As Mr. Revel mentioned, the language of the search warrant dictates that the search may be performed on Mr. Edwards' immediate person and vehicle only. Since Mr. Edwards was not in possession of the phones at the time of the warrant being served, the deputies are not entitled to them. If the deputies had acquired a search warrant for the phones themselves, then they may have had some authority to seize them. But the validity of such a search warrant would be questionable.
You can't get a search warrant for a thing. I can't get a search warrant for a cell phone and say, I want a cell phone, and I don't care where it's at, but wherever it's at, I want to go get it. You can't get a search warrant for a thing, has the thing as a subject. Otherwise, I could just get a search warrant for drugs, and I could go search anywhere where I thought drugs were at. Anybody, anytime, any place, anything. That's why you have to be specific. The purpose of that is to stop tyrannical governments from abusing their authority and searching and harassing anybody without justification.
Considering that the defense also intends to submit the phones as evidence. The search warrant presented by the officers does not authorize them to search Mrs. Garcia, but the prosecution does have a trick up its sleeve, which we will discuss later in the video. After realizing that Mr. Revel is refusing to comply with the search, Deputy Ashworth calls the district attorney's office for advice on how to proceed.
Okay, that's pretty smart on her part, calling the DA. Hey, we got a warrant, but the attorney has it. Now, the DA should have said that the focus of the warrant is the cell phones. We think there's evidence in there, and we want those cell phones. Detain these two right now, and you're detaining them pretty much like I talk about where you're preserving a house. If I think there's evidence in the house, and somebody says, you ain't coming in, and I said, well, I think there's evidence in there, and I need to come in and secure the house. And they go, no, you can't. You don't have a warrant. I got two choices. I can pull them out of the house, then do a protective sweep of the house, make sure there's nobody in there that can destroy the evidence. I'm not searching for the evidence. I'm searching for people that could destroy the evidence. Then I secure the house, and then I go get a warrant for the house. This is what they could have done here. They could have secured you two and said, you two are staying here. Nobody's touching the phone. If you reach for that phone or touch that phone, I'm going to take it as you're destroying evidence, or you're attempting to destroy or tamper with evidence. So we have two choices. You can either give me the phone, or I'm detaining you until I go get a warrant to search your bag. Then I go back, I write a warrant, and I basically say in my warrant, and I attach the warrant for this guy as Exhibit A in my warrant, and I say, I need a warrant to search the attorney's assistant's bag, a black bag, being held by so-and-so who works for attorney so-and-so. The attorney represents the subject of the original search warrant, see Exhibit A, and I want to search that bag for the phones because I have video evidence that the subject gave the phones, which is the target of my investigation and the evidence, to this person, and I believe that those phones are in that bag, and I want permission to search that bag and seize those phones. And then the DA signs off on it and says, I agree. I think your probable cause is good. They bring it to a judge. The judge says either one or two things. Seize the phones, or the judge could say, I want the attorney, the assistant, and the phones, and the subject, and the cops brought before me right now, and we're going to have a hearing. And they get this attorney, and they get the DA, and everybody goes in court. And the attorney goes, look, Your Honor, according to attorney-private privilege, case law, blah, 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 I do not have to give these, and the attorneys, or the DA is not entitled to these phones because they're in my possession. I represent my client. I can't be compelled to give evidence against my client. And then the prosecution goes, Your Honor, that's not true. According to Peoples versus Doodly-Wop, it says that if I know an attorney has this phone and it contains evidence, therefore he's committing a criminal act by seizing these phones and not giving them to me, and he loses attorney-client privilege, he commits a crime, and by holding these phones, I believe he's committing a crime. And then the judge has to figure it out and says one of two things. She either says, attorney, give the phones to the prosecutor. If you don't, you're going to be arrested for contempt of court. And he gives the phones. Or she says, you know what? Give the phones to me. Has the court, I'm going to assign a special master, which is a non-biased attorney hired by the court, and he looks over things and he decides what is covered under attorney-client privilege and what isn't. And then he comes back to the judge and says, Your Honor, I think this on the phone is covered by attorney-client privilege. I think this isn't. I think the prosecutor is entitled to this, and I think they're not entitled to this. And then the judge issues an order and said, prosecution, you can only get this off the phones, or you can only get this, or I'm going to give you the whole phones, or whatever. That would have been the proper way to handle this. So the DA and the cops, in my opinion, are dummies. But
Hi, we're standing here, and we have it on video that he handed his cell phone to his attorney, one, and they handed it to another, and it's in the satchel that is right here.
Well, are we being detained?
At this moment in time,
They're not denying it. We have it on
I'm going
video.
to detain you until we determine the next course of action.
Okay, so the attorney was good. He asked a good question. If we're not being detained, I'm freaking leaving. And you ain't going to get the phones. How about that? But the cop went, you're being detained. Attorney went, okay, I guess I am. I don't think it's lawful, but go ahead. I think the detention is lawful. And the worst case scenario is they detain you. The detention is minimal. It's very non-intrusive. I'm just restricting your movement. I'm not searching you. I'm not doing a strip search. I'm not locking you in the back of a police car. I'm merely holding you till I get a warrant. And then the judge comes back and goes, you know what? If he gave it to his attorney, you don't have a warrant for that, and I'm not willing to issue an attorney and make an attorney give evidence on his client. So you don't get the phones. And it ends right there. Everybody goes home. That's what could have happened also.
Give me
Well,
just a minute.
but I have this person and vehicle.
It sounds like she's talking to somebody who's not familiar with the warrant. If the DA signed off on a warrant, he should know what the hell the warrant says because he signed off on it. So for her talking to another DA that did not sign off on a warrant is another stupid rookie mistake.
Turn this off. I think what we just done.
Okay. Okay. We either need the phone out of the satchel or we will have to detain you and get a search warrant.
Hey, perfect. I didn't hear her say that the first time I watched this. That's perfect. Either give us the satchel or we got to detain you to get a warrant. That's exactly the correct response. I don't know how they got to arrest.
To get the phone.
So you're going to, well, okay. Well, we're not going to give you anything that's on our person that you don't have a right to. So if you...
Good for the attorney. We ain't giving you nothing. Perfect. Then you're detained till we get a warrant. No problem. Go get your warrant.
detain us, you have to have, there's certain constitutional safeguards to do that. But you're going to detain us, then hey, we're not going to run.
So he's being cooperative. We're not going to run. We're just not going to give you the stuff because you threatened to detain us. If you want to detain us and go get a warrant, no problem. Perfect. No problem.
You all are telling us we are being detained. Is that right?
This point in time right now, you are being detained. Now, they determine.
Okay, you both are under arrest for obstructing government.
Oh my God! What the fuck? I couldn't believe it. I was like, are you kidding me? And you know what? I think this is freaking perfect. Because until cops and government starts eating their own, they will not change the law. This is a unlawful arrest. This is a bullshit arrest. Unfortunately, they're going to get paid by the taxpayers, and these cops and the DA that sit around. I guarantee you the DA go, you know what? If they don't want to give us phone, screw it. Just arrest them for obstruction. And this deputy went, okay, no problem. The DA told me to arrest him for obstruction. He's got immunity. I got immunity. I'm acting in the course of my employment. I'm within policy. Screw it. Let's just arrest everybody, and what do we care? We get immunity. That is freaking BS.
Operation.
Obstructing government operation.
That's correct.
What are you going to do? You're going to arrest him with your freaking suitcase you carry around concealed as a purse? Or are you going to arrest him with the paper? What are you going to make some origami here and freaking make a little set of handcuffs with your paper you keep carrying around? What the hell kind of cop is? You're a freaking freakazoid, woman.
This is definitely an unlawful arrest. But we're under arrest.
He's correct. It is an unlawful arrest. But he's cooperating. He's saying if we're under arrest, we're under arrest.
Mr. Revel is more than correct that this arrest is unlawful. Not only are the deputies charged...
I don't know who this guy talking is. He's talking like he knows what he's doing, but he's saying things that don't make sense. I don't know the guy. Don't be hating on me. Don't be calling me I'm a mean guy. He's smart. He's an attorney, whatever. It doesn't sound like he's just kind of parroting kind of what's going on without any actual experience to understand why. Or maybe he's not explaining it well.
Charging Mr. Revel under the authority of an irrelevant search warrant, but neither Mr. Revel or Mrs. Garcia did anything that would constitute a violation of Alabama Code 13A-10-2. The code states that a person commits the crime of obstructing governmental operations if, by means of intimidation, physical force, or interference, intentionally obstructs the administration of law or prevents a public servant from performing a governmental function.
Okay. So he's quoting the law here. Well, he's saying they didn't violate this, but I can make a case that they did. There were 2 law enforcement officers on advice of the district attorney with a lawful search warrant trying to seize evidence of a crime against a child and a mother, which has sympathy in the courts and in the jury, and they were trying to destroy it. And had the cops did nothing, this will be what the DA and the cops will say, had we done nothing and let them go, we might have lost valuable evidence that we could not get, and the perpetrator of this abuse on this child would have walked free. And we thought, erring on the side of protecting the child, that letting this person go would have been a huge injustice, and therefore that's why we did it. And he was interfering because he had the choice. All he had to do was give us the phones. He could have argued in court later that we took them unlawfully, and he could have got the evidence suppressed. So therefore it is his fault, and it's not our fault. And then that's when it gets muddy, and the if, and, buts, and coconuts come out, and then nobody gets charged, and then the pesky taxpayers end up paying millions of dollars for unlawful arrest and unlawful detention.
Neither Mr. Revel nor Mrs. Garcia conducted themselves in a manner that was intimidating, physically forceful, or interfering.
Well, that's up to interpretation. Again, somebody that doesn't understand the law. The law is up to interpretation. Someone else may interpret, you know what, they did interfere. All they had to do was give the cell phone. Hell, I mean, this attorney could have said, you know what, I want to go in front of a judge right now. I want to walk in front of a court that issued that warrant, and I want that judge to order me to give me the phones, and I'll give it to you. I'll be more than happy to cooperate. I'll give you the phones if you get me a judge to say give it to you. And they should have, and they could have done that. And the DA should have done that. The DA should have said, you know what, I'll be right down. Let's bring it in front of a judge to sign the warrant. There were so many other options, but you know what? The default is, for government and power, arrest everybody, tase them, say they resisted, say they're interfering, and let the courts figure it out, and we don't care about the destruction that will live on forever.
They both simply stated that they would not comply. If the deputies were so sure that the search warrant authorized them to seize the phones, then what was stopping them from taking Mrs. Garcia's bag and getting them?
They knew, they weren't certain that the thing authorized them. This guy's saying, like it's a fact, that the deputies thought they were entitled. They did not arrest them because of the warrant. They arrested them unlawfully, and they shouldn't have. They should have just detained them. But basically, the arrest is going to be listed at detention. As soon as they get them downtown, as soon as they arrest them, take the phones, the cops can turn around and go, okay, we're going to release you now. And under this section, I think it was 849B in California. Maybe it wasn't 849. I think it was 849, 847B, something. Basically, it says you were detained and you weren't arrested. You're free to go. I don't book you. I don't take your fingerprints. I don't do anything. I just search you. I get what I need, and then I let you go. And then I let the courts figure out whether or not I can keep it or use it.
Certainly not Mr. Revel or Mrs. Garcia.
If anybody ought to be arrested, it ought to be this freaking impersonation of a cop wearing the tie-dye tent, running around screaming with her hair on fire. Women's rights! Women's rights!
Sir, if you would, turn around and make sure you don't have no weapon on you at all.
Of course not.
Okay.
Okay, they just came out of court, and they just walked through probably a metal detector. I don't know. But anyway.
Make sure.
We have it on video.
We have not broken the law. So if you're arresting us.
That is a great point. They have not broken the law. But you don't need to break the law for cops to arrest you. That's a misunderstanding that people have. They think they have the right not to get arrested. They don't break the law. No, you don't. You have a right to fight it in court, maybe prove it later. You have a right for the DA to offer you a plea deal. You have a right for the DA to dismiss the charges for lack of evidence later. But you don't have any right not to get arrested. Rick, you're a bootleg jack. Don't hate the messenger. I'm just telling you reality, people. This girl's really nervous. She's probably never been arrested. She's like, oh my God, I got a bag. You know, what she should have probably done is said, if I give the bag to him, can I not be arrested? The cops would have probably said, yeah. Because all they really want is the bag. She should have just said, or the attorney says, you know what? Give me the bag. I'm not giving you the phones. She's not involved in this. He would have liked that. But maybe the attorney is seeing dollar signs saying, you know what? I got a much better case to get more money if they arrest this woman and me, and we'll get double the money. Maybe that's his plan. I don't know.
I'm being arrested for obstructing government operations.
That's correct.
Let me take out this right here.
If you don't mind, put it in pocket. That way
Real life.
This guy's like, shit, who did I hire, man? My attorney ain't too good and shit. I come out and they arrest his ass. What the hell? Rick, you shouldn't laugh. This isn't funny. Our system is a freaking joke.
For this charge, you sure you are doing this?
Subject to the law?
I am subject to the law. Okay. And this is, and who are you?
I'm Sue Ashworth.
Sue Ashworth?
That's correct. And this is Brian Ratliff.
And you're arresting us under her orders?
I'm still not, because I still couldn't make out who the hell she is or what she's doing.
Yes, sir. Okay. Deputy Ratliff, yes, I want to make sure that you know from our position was that this search warrant, this warrant was given to him after he gave us some things for us to use and get the.
Okay, so that's kind of a key point here that he stuck that in there. When you serve a warrant, that's when the warrant is considered served or conclude, or you have 10 days to serve a warrant. I'm not sure the word I'm looking for, but once you serve that warrant, that's kind of like when everything starts. I can't serve a warrant. Now I'm trying to figure out how to explain this, but it's a good point that he pointed out that this warrant was served on this person after he gave him the phone. Had they walked up and said, we're giving you a warrant and we want your phones, and he handed it to him after the service of the warrant, they would be in a much better position for the obstruction. And I'm not sure how that would have changed things. It would have changed it a little bit because he would have been trying to conceal evidence by giving it to him. If he had a gun or drugs and he tried to give it his attorney would be like, hey man, I can't take that. They just served a warrant on you. If he had the phones and they served a warrant, he tried to take them, the attorney probably go, hey man, if this is subject to the warrant, it was on your person when they served you, therefore I can't take it. That would have changed things.
And so we did not do anything to keep you all from doing you all's job. Now, if you all want to
out here
this
with
satchel and go
the
through
sheriff's
and do it,
office at the courthouse.
we're not preventing you from
Doing a search warrant on the car. And
so I just wanted to make
I'm
that
out here just.
From the moment he's entered the courthouse, he's been under surveillance.
Yeah.
Okay?
That doesn't matter. If you had a search warrant and you knew he entered the courthouse with the 3 cell phones, why didn't you serve it then? You had the warrant. Why didn't you serve? This cop's trying to say, well, he's been under surveillance and we knew. He didn't know there was a warrant. He didn't know that they were going to try to take the cell phones. He didn't give it to him to prevent them. They took it because they wanted to find evidence to support him. So there's no conspiracy here, and that may be where this cop's trying to go. I doubt it. I don't think any of these guys are very experienced.
For the reasons of this search warrant. Alright? I'm sitting here and watched you and him and her.
Can't believe we get about 10 or 15 minutes. I'll be ready.
You looked up. As a matter of fact, you did look up at the camera 2 or 3 times.
Here's a news flash, Sergeant Deputy Dog. Looking at a camera is not a crime. But I just thought I'd throw that out there.
He pulled the phone out and handed it to you. You handed it back to him. He was fooling with, I'm guessing, a password. And after a short period of time, he handed it back to you. You handed it to her. She put it in here. Okay? That is evidence for this search warrant.
So, the phone is the evidence that they're looking in the search warrant. He is correct there. And that video may be evidence that on what he said happened really happened. But there was no crime. Now, if it comes out that this guy found out from a court reporter that they have a search warrant, and as soon as he walks out of the courthouse, they're going to seize his phone, and that comes out later, then this attorney has issues. But absent that, man, these guys got a good suit.
And you agree with me that you all served this search warrant on him subsequent to that, after that, all right?
Yeah.
After we left out the building.
Yes.
The deputies fail to understand the authoritative limitations of the search warrant, and Mr. Revel and Mrs. Garcia were arrested and charged under Code 13A-10-2. The prosecution initially offered to drop the charges if Mr. Revel agreed to write a letter apologizing and admitting that the deputies did nothing wrong.
Oh my God. So the DA is going to hold an arrest over their head and say, you know what? I'm going to do you a good solid because, you know, you're an attorney and we're brothers and everything in the attorney bar world. So I'm going to cut you a solid. If you plead guilty, I'll drop the charges if you write a letter saying the deputies did nothing wrong. And the reason why the DA wanted that, because that would negate a civil lawsuit later. If he came back and sued, they'd be, Exhibit A would be this letter saying, hey, you said they didn't do anything wrong. Wouldn't have made a difference, but it would have helped the prosecution case.
But Mr. Revel rejected their offer and decided to proceed with a trial. In the ensuing criminal trial, Mr. Revel and Mrs. Garcia's defense argued that the state failed to establish the defendant's intent and that no crime was committed because the search warrant did not authorize the search of Mr. Edwards' attorneys. The prosecution argued that they were entitled to the phones under the exigent circumstances doctrine, which...
Okay, if they wanted to pull, which I would think a judge would have told them that, if you're going to seize evidence under the exigency clause, you have to state the emergency. Because you detained them and you could have got a warrant, there was no exigency. Now, had this attorney said, I'm leaving and you go get your warrant, now I think there's an exigency. If he gets out of sight, he could destroy evidence, and I don't want him leaving with that evidence. But as long as I can secure the evidence and get a warrant in a reasonable time, shit, they're in front of the freaking courthouse. It's not like they got to go try and find a judge. There was no exigency. Exigency is an emergency action. It's to say I got to do something immediately, and if I don't, I'm going to lose evidence. There was no exigency here, and I can't believe that the prosecution even argued that.
Which is a legal precedent that allows for warrantless searches in circumstances where evidence has a high likelihood of being destroyed, such as cell phone data. I have covered the exigent circumstances doctrine in a previous video, which I will link in the info card above. During the trial, Mr. Edwards, who was still under investigation at the time, testified for the prosecution, but stated that District Attorney Casey tried to prep him in his testimony, even though she had reportedly recused herself from the case, and Mr. Edwards became a key witness for Mr. Revel's defense. Ultimately, Judge King acquitted Mr. Revel and Mrs. Garcia of all charges and stated that the deputies were wrong about the authority of the search warrant and that the defendants never physically prevented the deputies from carrying out their duties.
I agree. But guess what? They still got arrested. They still got booked. They still got searched. They still had to postpone. They still had to go to court on their own time with their own money. The prosecution offered to drop the charges for a letter, and they didn't because they knew they were wrong. And now what? Now the pesky taxpayers will pay in a civil trial.
Mr. Revel and Mrs. Garcia were forced to recuse themselves from Mr. Edwards' case after filing 2 separate federal lawsuits against Deputy Ratliff and Deputy Ashworth.
Good for them.
As well as District Attorney Casey and the Assistant District Attorney Scott Gilliland. It is worth noting that Mr. Edwards has yet to go to trial, and his case has been reset by a different grand jury several times over the past 2 years. It is highly irregular for a district attorney to delay indictment when the suspect has been charged, and there is merit to the notion that she may be delaying Mr. Edwards' prosecution so that she can use his pending case as leverage against him for his testimony in the federal law.
Of course. They're going to say, you testified for us. And when they say he testified for us, maybe he testified, my attorney said, why don't you give me the phones so they can't get it, or something like that, which would have been attorney-client privilege, but he breached the privilege because the privilege is his to assert. Therefore, he didn't violate the law, but he turned on his attorney, which is kind of chicken shit if he hung this attorney out. But now the prosecutor says, this is our star witness. We can prevent a lawsuit as long as we make him testify. And if he tries to change his story or he doesn't cooperate, we've got this criminal charge to hold over his head. So we don't want to settle the criminal charge till he testifies. And they're probably telling him, once you testify truthfully, they always like to use the word truthfully. Truthfully means what I want you to say. That when a DA uses, I want you to testify truthfully, that means I want you to say what I want you to say. They don't care about the truth. and I've seen this done by many DAs many times, is bullshit. But anyway, I hope this guy wins a big suit. Unfortunately, taxpayer pay. The district attorney and these cops will absolutely have no damage, no punitive damage, and aren't worried about a damn thing. They'll continue to get paid by the government. They'll continue to get free representation by the government, and they'll continue to do their job and get paid, and we'll have no fallout, negative fallout on this whatsoever. Man, this is a bad case. Anyway, I thought it was interesting. Well, then out there,